streaming the truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness turns tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tune in every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces tell stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Hey everybody. Hello, everyone. Good evening. As promised, I said I was going to come on and give you guys some 411 if you guys have some questions to ask me regarding today's event of the trial. As you guys know, both sides has rested. The defense didn't put on any kind of argument. I mean, they didn't have any kind of witnesses, and they decided to close out, which I thought that was a great move on the defense side, because really they don't have to prove themselves. They really don't have to prove their case. And the state, based on what I've heard and what I've seen, I don't think the case put up a strong enough argument for it to go, for them to really have to try to defend everything. And I know they wanted the defense to try to try to figure out where like the alibi for Mr. Faust, which he didn't have to give an alibi. It's not his duty to show himself innocent, because right now he's considered innocent until proven guilty, right? So the defense did not, and plus it was really hard for them because a lot of ruling went against them, and there was a lot of things being allowed in the case, and it really didn't make any difference, I don't think, for him to even do any kind of putting up some case in chief. It didn't really make sense, because it wasn't going to help anything. If anything, it probably would hurt the case. And right now, while they were ahead, might as well just stay ahead like they were, right? So they did close. They did end up not bringing any witnesses up, and the judge went over the charging elements of the case, right? Both sides came in and did their submitted their what they felt needed to be part of the charging element for the for the the uh the jurors. I had to think. The jurors. So what I'm going to do is share with you guys some of the stuff that happened in the courtroom while we were out, because I know some of you guys was asking me earlier, why did they why were they yelling? I mean, why, what was the outburst in the courtroom and certain things like that. And if you guys have any question, you can go ahead and put the questions in there, and then I'll answer some of you guys questions, okay? But when I got there, there was some people out there protested, and it was mostly his family that was out there protesting on the in the case. It's about, I think it was about like 6 or 7 people out there as I counted. I think it was 6 or 7 people, but they were mostly his family. And the courtroom was empty when I first got there. It was empty because they were doing the charging elements of the case, right? They were doing the charging elements. And in fact, there was like 1, 2, 3, 4, 5, 6 individuals that was in the courtroom, not counting the deputies and things like that, but 6 individuals, counting including myself and the camera guy, Maurice. So it was 7 of us all together in the courtroom. We sat there. It was really boring going through all those papers. I think they had like about 17 pages or something like that. It was a lot of pages, and they were going through it. Maybe might have been 20 pages, and they were going through it really slow, and it was really boring. So I went to lunch and went to go get some lunch, and then when I got back, it was time for them to do the closing argument, right? And the state went up first, right? And then he did his commentary. I said commentary because he really didn't give any kind of closing argument, and I guess because he wanted to see what the defense was going to say, and then he was going to do a rebuttal to what the defense said. So he just basically gave an introduction type of thing. He didn't say much, guys. I was like, that's it. He didn't say anything that was like sufficient for it to be really an argument. So I said, okay. Then he was okay. If you guys heard, there was like, let me see if I can play this thing right now, and then I can explain to you what the uproar was. Hold on a second. Let me just pull up my link. Hold on. Hold on a second. I have to get my link. Okay, hold on a second. Let me pull it up on my email. Hold on a second. Let me pull it up.
Okay. Mr.
Whatever you would like to do.
Mr. Cruz, I'll hear from you in terms of your witnesses. We're going to need certainly the information for your WebEx people. And so I'll hear from you in terms of your witnesses, how long you think this is going to take. You may not know. But if you have any idea of where we're going, certainly.
By noon, I still have to talk with the team to figure out exactly what order we're going to put individuals in.
Okay.
As far as the WebEx information, I can provide that to the Honorable Court now.
Okay. We're gonna get, it's one of the reasons why I have the jury coming in a little bit later this morning is we need to get that set up because I didn't have that information yesterday. So if you can actually send that by email right now to Miss Ellis, we're going to get that to Miss Craig, who is in the other county. She's in Oconee County, helping to handle court out there, and we will get her to set it up.
I need to call her. She's not local. I advised the Honorable Court of that, so I need to call her just to let her know that.
When we're ready to roll. Sure, absolutely. But if you'll send the emails where we need to send the WebEx, I think we'll put both of them on for the same time.
That was pretty smooth, y'all.
Let me ask you this, Mr. Cruz. Do you already know the order of those witnesses? Which one's going to go first?
I don't. I need to speak.
Okay, all right. I'll let you do that. Do that and let me know. I think I'm just sort of thinking out loud. I think that's better for the WebEx, that we'll try to do it in the order that you're going to call them, so they're not both on the same WebEx at the same time. Yeah.
Wait to the motion in limine.
Okay, sure. All right, very good. Any motions you want to present, Mr. Yelman-Chile?
Yes, Your Honor. Thank you. My understanding is, at least in part, we're not sure who all the witnesses are going to be that Mr. Cruz calls, but it is my belief that he intends to recall Detective John Newton, as well as call Detective Mike Tyndall and Kashana Armstrong. As it relates to Detective Tyndall, the state would make a motion in limine regarding any testimony about alternative suspects other than Mr. Melton, as has been referenced several times during the trial of this case. In pretrial motions, the state filed a Sadi motion. Mr. Cruz identified only Chris Melton as an alternative suspect that the defense would offer before the jury. Detective Tyndall, I think it's actually Sergeant Tyndall, if I'm recalling correctly, is a law enforcement officer now with the Oglethorpe County Sheriff's Office. At the time, he was with the Athens-Clarke County Police Department. In part, he interviewed individual by the name of, Stephen Barden, who was a law student at the time. And he also interviewed an individual by the name, I believe, of Anthony Little, who was a resident of Athens-Clarke County at the time. These individuals were interviewed as initial persons of interest, but no evidence was ever developed to link them to the crime. And therefore, in addition, Mr. Cruz hasn't provided notice through in response to the state's Sadi motion, so no evidence of anything related to those two individuals would be relevant, and under a 403 analysis would be confusing and misleading to the jury. So we would make that motion in limine. Also, it's our belief, and obviously we do not know this for sure, that Mr. Cruz may be intending to attempt to question Mr. Newton and Sergeant Tyndall regarding certain phone records for which there is no records custodian who has appeared on the witness list in order to testify to authenticate those records, and no notice of intent to introduce the records without a records custodian has been filed. Obviously, we ran into this issue with another witness, which is why the state is making a motion in limine at this time that those records should not, these witnesses do not have the ability to authenticate those records in an appropriate way to lay the foundation for their admissibility. And so those records should not be used as a method of questioning these witnesses or raised as far as their contents in reference to the questioning that Mr. Cruz would do, or, even if they're not admitted into evidence, the information in them cannot then be used in the questioning in an effort to introduce hearsay evidence through questioning of witnesses who aren't able to lay the proper foundation for the admission of those records. So those are the motions in limine that I wanted to present, Your Honor. And I know that the way we've split up the cross-examination of possible witnesses that Mr. Cruz may call, if I could have just a moment to consult with Mr. Bolden.
But you were talking about the phone records with regard to the witness. Mr. Cruz is calling Sergeant Tyndall. Is that right?
Sergeant Tyndall and Mr. Newton.
Oh, and Mr. Newton. Okay.
In the recall, I believe there was an attempt the first time that Mr. Newton testified in order to introduce those business records, and the court made a ruling that there was not a proper foundation laid for their admission, and then they could not subsequently be used in the manner that Mr. Cruz was attempting to use them, basically making a motion in limine to continue to adhere to the court's earlier ruling and prevent that process from playing out in the exact same way again. And then it's a similar argument with Sergeant Tyndall, because I think that those two witnesses are similarly situated as it relates to the phone record.
Boy, let me tell you, I'm just gonna tell y'all something. Sitting in court listening to them talk, it kind of reminds you of Charlie Brown. Wah 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 wah. Because I was like, okay, he's going on and 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 saying the same stuff over and over and over again. So I was like, yeah, no offense. Don't take any offense of what I'm saying. I'm just giving you my opinion on how I felt when he was just talking. I'm like, oh my God, this man has many words. You know how they say women got a lot of words? This man has many words. Many words. It's like elongated, like, wow. He was just making my mouth tired. I'm just telling y'all how I felt. I was like, Lord have mercy, my mouth hurt because it feels like I'm talking that much. I mean, he kept going on and on.
And their inability to testify to foundation for admissibility of those records.
All right. Thank you. And you may have a moment, Mr. Bolden, and then I'll hear from you, Mr. Cruz.
Okay. Your Honor, Mr. Bolden will be making a motion in limine as well.
All right.
Morning, Your Honor.
Morning.
Yes, Your Honor, just to kind of piggyback on what Mr. Yalamanchili was just discussing, this is specifically as it would relate
Okay,
to
y'all, I know y'all don't want to hear the whole
testimony.
thing over again. Let me go some forward
One of
to
the
where
things that the state expects
we-
the defense may try to elicit through its
let's go a little bit further in.
Regard to a witness that you wanted to call, Jessica Gann, let me ask you this so I'm clear on what you're saying. Well, let me just ask you, what is your position on the state's objection about hearsay? Yes. I mean, they've objected on other grounds as well, but what about the
It
hearsay?
goes to notice. That's my response. It's not hearsay because it goes to notice. That law enforcement was on notice about this information and they didn't follow up on it. We're not offering for the truth of the matter. We're offering it to show law enforcement, which is one of our multiple defenses in this case. I think a big part of the state's case is that law enforcement had information that they just failed to follow up on that would have resolved this case 20 years ago. So it's just notice. This goes to notice that law enforcement was aware of this fact and they didn't follow up on it.
Thank you, sir. I think at this point, what the law would require, Mr. Cruz, is that if the defense's argument is that these statements that certainly I would say at this point would confuse the jury about anything that may have happened at a Mexican restaurant with a person's statements who have not been elicited in court at all. I certainly would say that under 403, we are talking about confusion of the issues and misleading the jury. I think that's certainly a problem. But I would say that at this point, Mr. Cruz, the defense would have to provide evidence to what you've just stated. I mean, a blanket statement that you're making that if law enforcement had followed up with Jessica Gann, this case would have been over 20 years ago, is that's a pretty spectacular statement. And in order to ask the court to admit those statements in lieu of that comment, the defense has to provide the court some evidence.
But my question is, isn't testimony considered evidence? Isn't testimony what they consider evidence? So if he's going to bring up a person that's going to speak on that particular thing, why can't it be evidence? Maybe somebody else can help me understand that. Why can't that be considered evidence? If he's going to bring somebody who's going to testify to that particular thing. But I won't say no.
That would in fact have been true. And without that evidence, that testimony that you are seeking to elicit, certainly I would say falls under the category of misleading the jury, of confusion of the issues. And it really does come close to that line that we have been discussing this entire time, which is the order that there are to be no statements by witnesses about other suspects other than Chris Melton, which you properly gave notice to the state for. So, you certainly can respond to what I've said, and then we're going to kind of move on, but go ahead.
So two things. My statement, I think I may have said it wrong to take it out of context. So my statement wasn't, or it should not have been, and forgive me if I said it this way, isn't that, hey, if they solely would have talked to Jessica again, this case would have been resolved. I believe I stated it the wrong way. What I was saying is if law enforcement would have followed up on all leads, this case would have been resolved. As far as the 403 ruling, Your Honor, the state didn't object on the basis of 403. I understand the court could make any ruling that it deems appropriate, but the state did not object on 403 grounds. The state objected on hearsay grounds, and we provided our response to the hearsay. I would like the opportunity to provide a response to the Honorable Court's objection regarding confusing the issues for the jury.
You certainly can. I thought Mr. Bolden did make a 403 argument, and that's fine. I'll let you respond regardless, but I think he did. But the court has an obligation, regardless of whether the state or the defense talks about 403, the court has an obligation to respond to 403. So you certainly can respond.
Sure. So in regards to 403, as far as confusing the issues, this statement from Mr. Newt.
Why would the court bring up 403 if the other party didn't bring it up? That's just like the court giving help to that party by giving them a certain argument. Right? Let me shut up. I don't know what I'm talking about. I'm not an attorney. I just come up.
Require a mini trial to determine facts of issue. It's simply a building block on the facts in this case that support our position. I don't think that one fact I think we're on the 9th day of evidence, maybe? We're on the 10th day of evidence. We started last Monday, if I'm not mistaken.
9.
That one
There's
fact
nothing yesterday.
out of 10 days of evidence, I don't believe that will confuse the jury where they say, hey, we don't know what the heck is going on in this case. I can't believe Jessica Gann said that she saw Miss Baker. So that would be my response. I do not believe that one fact would confuse the jury, Your Honor, and I'm not sure. Did you say waste of time also?
I did not.
You said confusion of the issues and one more.
Misleading the jury.
And my argument would be the same. I don't, out of 10 days of testimony, and of course, the Honorable Court has all the wisdom, I don't believe that one fact would mislead the jury to making a decision in regards to the indicted charge where they say, we have this fact. Now we don't know if Mr. Faust is innocent or guilty because of this one fact. So I asked the Honorable Court to reconsider its ruling under 403.
All right. Thank you, Mr. Cruz. I mean, I think the argument you've just made supports the court's conclusion that any evidence regarding this Jessica Gann person, first of all, it certainly sounds like hearsay. I understand what you're saying, Mr. Cruz, that you're not offering it for the truth of the matter, but I think there's an argument to be made that you are, but I'm not finding that it's relevant. I think at this point, given the comments that both counsel has made, it would be incumbent upon the defense to provide evidence as to why any testimony by Jessica Gann would be relevant. And so I'm going to grant the motion. I'm going to find that it is not relevant. it is hearsay, and there's no exception to overcome the hearsay. Under 403, I certainly do think at this point, bringing in another person to suggest evidence that is not supported is a very significant moment of misleading the jury and confusion of the issues. And so under 403, I'm going to grant the motion as well that Mr. Bolden has made. There will be no testimony allowed to be elicited from Mr. Newton about Jessica Gann. No testimony elicited from Sergeant Tyndall regarding creations of phone records unless you can present a witness that can lay the proper foundation. Let's make this clear, though. I want to talk about this. Is there an objection from the state? Let's do this right now about Mr. Cruz asking Sergeant Tyndall whether he was able to get phone records.
And that's what I was, can I respond before this? He
Sure.
laid the foundation for the phone records.
Sure.
The court order he obtained, via recognizing the phone records, via stating that
Right.
those phone,
Right.
that they didn't appear to be altered. So he laid the foundation
Sure.
for the records that he received.
I remember that. I have that in my notes. But let's just get this out now so we're not having any, problems
I
later.
do not believe that there is anything wrong with asking Sergeant Tyndall if he obtained phone records. However, whether the police officer got phone records back as part of his court order is not the proper foundation for admissibility of those phone records.
I understand.
And so that's what our objection is.
This is the weirdest case ever. They're not allowed to bring phone records. I've been to so many trials, and phone records was definitely evidence that was helping or not helping a particular person's defense or alibi, because with the phone records it would give like some background of what was happening between Tara and Chris. Okay, you would have seen whether or not how many phone calls that she made to him before the breakup. You know what I mean? You would see that like right before the actual unaliving happened, you would see whether or not he tried to reach her. That type of thing. Even with his cell phone, you see where it was pinging from off the tower. Y'all get what I'm saying? So I don't know. I don't know. I'm not a lawyer. I'm not a lawyer. I'm definitely not a lawyer. And that will help to try to narrow down whether or not that person was in that area. The possibility whether or not they could be the one to do it, because it would have ping off of those towers. I'm just an observer. I'm just an observer. That's it. I'm just an observer. That's it. So I don't know. It's just, but I'm glad they put it down on record. So then that would help in appeal when the appeal time comes, if it goes the other way, because at least he would have asked for it. All right. All right, let's go move over. Let's move on. Let's see.
There's rebuttal. This testimony will become relevant as serve rebuttal, depending on what.
He's gonna come back and he's gonna tell him, nope, I'm not gonna go. I don't blame him. I would have closed. I would have ended too, because they're trying to stop me.
Last line of count 12, well, the third line from last count 12.
Hold on. I want to see what he says.
The good order and
When he came back and said he wasn't gonna go out. Okay, hold on. Okay. This is it. Sorry, y'all. My sinuses is bothering me. Let's see.
Conference. And it is a conference, it's a meeting with the court and all the attorneys about what law is to be given to the jury in its charge. That is something that, of course, has to be done.
Way, since Mr. Cruz did not identify them as individuals he intended to raise as alternative suspects in response to pretrial motions hearings.
All right, thank you. All right, I don't know why I wrote Ms. Armstrong's name down, and we have to get her WebEx information. That may be why I wrote to go to admit those statements under that theory. And in doing so, that would bypass the court's order that it has already granted.
My throat is itching. I was trying to see the part when he says, hold on a second. I know y'all asking me questions. Hold on a second. Let me just go get to the part where they start the closing arguments. That was a long process right there.
Actually disproving anything in count 10.
It just needs to read to the word. We've already given this.
Or extrinsic act, as is going to be confusing. So,
All right, here we go. Here we go. We're going to start the closing argument.
Needs to speak to the jury and to please refrain from any talking, any comments, any audible noises of any kind. It would be very distracting, particularly for the attorneys who are trying to concentrate. So I ask for your cooperation in that regard. All right. Is the state ready to bring the jury out?
Judge, I think Agent Bigham was on her way up.
Okay.
This has the state's
Okay.
closing PowerPoint.
Okay. We'll wait for her to get here. She's in the building.
She is.
Okay.
She was literally just on our third floor office space. So I think she'll be here in just a moment.
Okay. Other than that, state ready.
Yes, Judge.
All right, Mr. Cruz.
I have one question.
Sure.
Mr. Faust's video as an example. We have different timestamps. Is it okay if I use, because it's in evidence, but I have a version where the timestamps are different. I can just go to the portion they play. Can I use that portion for closure? It's the exact same video.
Sure. I mean, I would say as long as it's the portion that everyone, you both stipulated to was admissible. I mean, doesn't matter to me what number it is on your computer, as long as we're clear on the portions that have been admitted. So, sure. Anything you want to respond to that? Okay.
No, I mean, as long as it's only the portions that were published to the jury.
Right.
I don't have any
I mean, that's what I mean. Right.
Start working with the knife that will need closing out of discovery. Is that okay?
Yes. Let's go ahead and get that taken care of. And we're waiting for Agent Bigham also. So. I guess while I'm thinking about it also, this is not for the attorneys. This, again, for the audience, I'm going to ask that you all remain seated until we take a break. It may be that somebody does need to leave, and I certainly understand that. But if you can limit, please, your entering and leaving and coming back into the courtroom, it would be very much appreciated. It's really distracting for the attorneys, quite frankly, and I certainly want to give them all the most opportunity they can to concentrate. So I thank you in advance for your cooperation.
I'm going to go briefly to begin with, and and then I'll close.
All right, y'all, let's you're right, Lil B.
Yes, ma'am. Please don't tell me the computer went down.
Okay, let me flash forward. It was definitely really good. His closing argument really had the attention of the gallery and also everyone in there, because there was some people really in tune to what he was saying. And I heard
All right, very good. I'm going to bring the jury out. Once again, counsel, we all ready for the jury? Mr. Almachili?
Yes, Your
All
Honor.
right, very good. You may bring the jury out. Thank you.
he seemed like he had a lot on his mind today.
All right, you all may be seated. Welcome back, ladies and gentlemen. Thank you again for being on time. You have always, this entire time, you have really been on time, and I appreciate it. We are now ready to do closing arguments. This is the State of Georgia versus Edrick Faust, SU 24 CR 0547. Is the state ready for closing arguments?
Yes, Your Honor.
Is the defense ready for closing arguments? Yes, ma'am. All right, thank you. Ladies and gentlemen, I want to tell you a few things. The first is kind of our timing. We are going to hear closing arguments, and then the court, of course, charges the jury, as I mentioned to you all earlier. I'm going to then have you go into the jury room and elect a foreperson. I'm going to then ask the foreperson to discuss with all of you whether you want to deliberate tonight, starting tonight, or whether you want to go home for the weekend and come back on Monday and begin your deliberations. So I'm going to give you that choice. So I just want to let you know sort of the plan. We are doing closing arguments.
You knew if they were going to make that choice of going home, because tomorrow is Valentine's Day. So you know these folks didn't want to stay all night trying to deliberate.
Arguments now, ladies and gentlemen, and I want to also tell you, as I told you at the beginning of the trial, that any statements made by the attorneys are not to be considered as evidence. Mr. Yalman-Chili.
Thank you, Your Honor.
Okay, we're going to stop in between and talk about what he said.
Bears with me for just a moment. I'm going to reposition the podium. On January 19th of 2021.
You heard him? January 19, 2021. Messed up right there. January 19, 2021. I was like, I thought it was 2001. Okay, 2021. Strike one on that one.
Tara Baker was taken out of this world. Her life extinguished by the defendant in this case, Edrick Faust. Mr. Faust entered Tara's home and caught her as she was going.
Why did he enter her home? That's the question. This is the thing you're supposed to be saying. How did he enter? Did he enter it through a bedroom? Did he enter it through a door? Did he enter it? How did he enter it? What evidence do you have that said he entered the house? What evidence? Okay, what evidence did they present saying that he went into, what proof do they have that he was inside that home at all? Was there a break-in? Did they find some fingerprints on the door? Did someone say they saw him inside the house? What was some of the evidence that was said that he was there? Did his phone ping off the tower saying that he was over there? What was it?
Going through her morning routine, he stabbed her, brutally bashed her head.
Okay, what evidence do you have that he stabbed her? Was his fingerprints on the weapon? Did the knife come from his home? Did you see him going to Walmart purchasing that particular style of knife, and you found it in the area where he lives? Did you find his DNA on the knife? That's the question. So how can you prove that he had that particular knife? What is the evidence you saw in that?
And strangled her as he forcibly raped her, sodomized her orally, and sodomized her anally.
What are the evidence of that? What are the evidence?
When she was discovered by firefighters and police, her hair still smelled like shampoo.
What does that got to do with it? Her hair still smell like shampoo. What does her hair smelling like shampoo have to do with the evidence of him doing it? Did he smell like the same shampoo too? Did you see the residue from that shampoo on his hand and on the DNA? I mean, what evidence do you have that he had the shampoo? Because you mentioned the shampoo. Why the shampoo? I'm trying to figure out the significance of this shampoo.
Ladies and gentlemen, you've heard the evidence in this case for 2 weeks and went through about a week of jury selection before that. And we're here at the closing argument after a family has waited 25 years for justice for their daughter.
They have not received justice for their daughter. You're just trying to find a way to justify your reason for this whole cold case stuff. I'm still waiting for the evidence, y'all. I'm still waiting. Other than the DNA that was found, that is. Let me shut up.
And it's time for you to write the last chapter of this story. The state, in closing argument, is afforded the opportunity to go both first and last in the summation. The reason for that is that we bear the burden of proof in this case. And that burden is guilt beyond a reasonable doubt. It's a burden that I accept readily. The burden never shifts. And the defendant is not required to present any evidence ever. And it's a burden that I accept readily on behalf of the state of Georgia, because it is a burden that we meet by bringing you the truth, the facts, and the evidence in the case. Not conjecture, not unsupported speculation, not statements about the evidence that end up being false after you actually hear it, but the truth and the facts of this particular case. You have a 12-count indictment that you will consider. And during this initial portion of our closing argument, we are not intending to tell you the same things that we're going to tell you at the end. I respect your...
Okay. Wait till you hear why they did the yelling.
Time. I'm going to try my best not to repeat myself. As it relates to count one is malice murder. And the law in this case will come from Judge Lott, and you should look to her jury charge in order to determine the law that applies to this case. But I expect that Judge Lott will instruct you that in count 1, malice murder, it requires that the state prove that Mr. Faust did unlawfully and with malice aforethought on January 19th of 2001 caused the death of Tara Baker, a human being, by strangling her with a cord and stabbing her. And in count 2 through count 5.
My question, okay, like when they have a case, when I've seen cases where they have evidence against somebody, right? They usually have like the blood splatter or that person's DNA or the fingerprints on the item that was used to injure that person, to unalive that person. And none of that was ever mentioned here at all. Not at all in the cold case. And I'm just trying to figure out.
5, I believe Judge Lott will instruct you that Mr. Faust is charged with felony murder as it relates to the felony offenses of burglary, aggravated sodomy, and rape. And I believe that what she will instruct you as it relates to those offenses will come in the charge, and we will discuss that. After those offenses of burglary, aggravated sodomy, 2 counts, rape, as well as possession of a knife during the commission of a felony, you will receive further instructions. And one of those instructions that Judge Lott is going to give you is about what we just discussed, the issue of reasonable doubt. And I think what the judge will instruct you in part is a reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based on common sense and reason. And I know sometimes it can be difficult as a juror to understand how you should weigh the evidence, but I think that the end of that second sentence is maybe the most instructive as to what a juror's role is. And a juror's role is to seek out the truth in the evidence that is presented before you. Your job is not to seek out doubt, it is to seek out truth. And the truth in this case is that Mr. Faust is guilty of each of the offenses for which he is charged in the indictment. I think it's important when we discuss malice murder to talk about what is required of the state in order to prove that. The state does not have to prove premeditation. The state does not have to prove motive. Malice aforethought in the state of Georgia does not mean premeditation. The state has to prove that Mr. Faust caused the death of another person, Miss Baker. He did so unlawfully, meaning without any type of justification, and he did so with malice aforethought. And malice as a term is used here is not necessarily ill will or hatred. It is rather an unlawful intent to kill. As I stated before, the state does not have to prove premeditation in order to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. The malice in this case is clear. I'm not going to display in front of you now those images from both the autopsy and the crime scene that you've been subjected to. I know that they are not pleasant images to look at, but if you are looking for evidence of malice in this case, the manner in which Miss Baker's life was taken was all the evidence of malice that's necessary to support a conviction under the laws of the state of Georgia. I think that the judge is also going to instruct you on felony murder. And although she will give you an instruction at the end, I think it's worth bringing up for you as you consider the evidence as argued to you by the attorneys in these closing arguments. And I think what the judge is going to instruct you is that for felony murder, the state must prove that the defendant caused the death of another person by committing a felony. In causation, as it relates to felony murder, I'd expect the judge will instruct you that you may find the defendant guilty of felony murder if you believe that he or she caused the death of another person by committing the felony of, and in each count, it will have the predicate felony or the underlying felony that's the basis for those felony murder counts. By committing the felony of whichever felony is the predicate, regardless of whether he intended the death to occur, there must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. And so when we're talking about burglary as a predicate act for felony murder, what we're talking about is the commission of that burglary, the entry into the...
Yeah. Okay. The burglary, entry into the home. There's no evidence of him being inside that home. There's no evidence of it.
Home in order to commit the sexual offenses that are relayed in the burglary being a substantial and necessary part of causing the death. The evidence in this case establishes that. It also establishes the predicate felony of aggravated sodomy being, again, a substantial and necessary part in causing the death in this case. It also establishes the evidence in the case that the rape and then the aggravated assault of strangulation and stabbing Miss Baker as predicate acts of the felony murder also played a substantial step in causing her, substantial and necessary part in causing her death. So that's what felony murder means. It means committing a felony that plays a substantial and necessary part in causing the death of Miss Baker in this case. I know that's not something that jurors typically know of necessarily as it relates to the way that the law is applied to those circumstances. So I felt like it was important to go over those things with you. The possession of a knife during commission of a felony, I think the arson in the first degree is pretty clearly self-explanatory. It's clearly from when Mr. Faust takes the blanket out of the living room, lights it on fire, and goes to start the fire in Miss Baker's bedroom. Possession of a...
Oh my God. He's making all these accusations, all this stuff without any evidence. There's no evidence of that. There's nobody that says they saw him start the fire. I mean, there's nobody's testify and say, hey, I saw him running out the fire and I saw him Dash had a gasoline tank with him and I saw him go inside the house and he snuck through the window, and there's none of that at all. No one spoke of anything like that. So how is it that he is the one that caused this and you don't have the evidence to show that? No proof. But you're just saying it because you got what? A DNA in her mouth. Then you try to claim that it was in her vagina, which you told a fib.
A knife during commission of a felony. Obviously, the knife used in this matter is longer than 3 inches in length. I think that's been clearly established by the evidence in the case. And then that knife was used in a felony involving another person, that being Miss Baker's murder as alleged in the indictment. So as you're listening to the evidence, those are the things that you are listening for. As it relates to the rape charge, that is carnal knowledge, meaning that Mr. Faust penetrated Miss Baker's vagina with his penis forcibly and against her will. The evidence of force and against her will is very clear from the images from the crime scene. As it relates to the offense of aggravated assault in count 5, I think that the aggravated assault being the strangulation with a cord and the stabbing. As it relates to the 2 counts of aggravated sodomy, one is for the oral sodomy, forcibly and against her will that was performed by Mr. Faust on Miss Baker. And then the other one is the anal sodomy, forcibly and against her will, performed by Mr. Faust on Miss Baker. Ladies and gentlemen, the next thing that I want to talk to you about is what is evidence and what is not evidence. Evidence is what you hear from the witness stand and the exhibits that are emitted, the videos that were played for you, and the things that will go back with you into the jury room. What I say is not evidence, whether it was an opening statement, whether it was in questions that I asked witnesses, or anything else that I've said to you. This closing argument is not evidence. It is my argument to you about what the evidence shows. The same thing goes for the...
Can I ask y'all a question? Let me stop. Let me stop. I was going to ask a question, but I don't want to be petty. I don't want to be petty, but I was going to ask y'all a question, but let me shut up.
Defense in this case. Nothing that Mr. Cruz says is evidence. No questions that Mr. Cruz asked are evidence. When there is a conflict between what you've heard on the witness stand and what it is that Mr. Cruz says or what I say, remember, what we say is not evidence. So when Mr. Cruz says to you that the hairs that were found in Miss Baker's hands were going to be proven to be Mr. Melton's hairs, that...
Excuse me. May I see counsel at the bench, please?
Ladies and gentlemen, you need to remain.
You hear what he said? Hold on.
Miss Baker's vagina with his penis forcibly and against her will. The evidence of force and against her will is very clear from the images from the crime scene. As it relates to the offense of aggravated assault in count 5, I think that the aggravated assault being the strangulation with a cord and the stabbing. As it relates to the 2 counts of aggravated sodomy, one is for the oral sodomy forcibly and against her will that was performed by Mr. Faust on Miss Baker. And then the other one is the anal sodomy forcibly and against her will performed by Mr. Faust on Miss Baker. Ladies and gentlemen, the next thing that I want to talk to you about is what is evidence and what is not evidence. Evidence is what you hear from the witness stand and the exhibits that are emitted, the videos that were played for you, and the things that will go back with you into the jury room. What I say is not evidence, whether it was an opening statement, whether it was in questions that I asked witnesses, or anything else that I've said to you. This closing argument is not evidence. It is my argument to you about what the evidence shows. The same thing goes for the defense in this case. Nothing that Mr. Cruz says is evidence. No questions that Mr. Cruz asked are evidence. When there is a conflict between what you've heard on the witness stand and what it is that Mr. Cruz says or what I say, remember, what we say is not evidence. So when Mr. Cruz says to you that the hairs that were found in Miss Baker's hands were going to be proven to be Mr. Melton's hairs.
He never said that. He's never said it was going to be proven to be Mr. Melton's hair. He did not say that. So that's why there was an uproar inside the courtroom.
That
Excuse me. May I see counsel at the bench, please?
Ladies and gentlemen, you need to remain.
They were like, they got upset. They got upset.
Another outburst like that, those of you who have made the outburst are going to be asked to leave and you will not be able to return. I don't know if everyone who made a comment heard me say this when I first got started, but this...
He said the evidence that, he said that Cruz said that it would prove that the hair that was found in her hand was to be Melton. He never said that. He mischaracterized what was said.
is a, well, I'll just leave it at that. If there are any other comments like that by anyone in the audience, I'm going to stop the proceedings. You will be escorted out by the deputy and you will not be able to return. And that goes for everybody that's in the audience. And I hope that I've made myself clear about that.
Whole
Thank you
audience.
very much.
Wow.
Your objection is?
The whole audience went wow off of that. Oh, let's go forward. So that was the first outburst, and then there was another outburst when the phone started ringing.
About the actual facts and evidence in this case that prove beyond a reasonable doubt that the defendant, Mr. Edrick Faust, is guilty of each and every offense in this indictment.
Mr. Cruz, closing argument.
All right. Now, Mr. Cruz, let me tell you, his closing arguments basically kind of lay out some of the things that were missing as far as what the state claimed that Mr. Faust did. And he kind of put it all together and kind of helped. And I heard some of the stuff that I've been hearing in different chat, different people who's been covering the case. And I'm like, wow, the folks, did they listen to the folks in the chat? Because some of the stuff that you guys were saying was right there in Mr. Cruz's closing arguments. So I was like, y'all got that. Y'all got that thing. Y'all had it on. It was interesting. We're not going to do the whole thing. We'll do Mr. Cruz interview. I mean, his what's the name tomorrow, because this one's so long. We'll do that tomorrow.
Fit the science. And you may have heard the state ask a question. Well, does the clock reset? And you heard Ms. Hinkle say, yeah, but it will require penetration. So if it number one, it wouldn't be there, but let's say hypothetically, it requires penetration. Whose DNA profile was the only identifiable DNA profile in Miss Baker's anus? It was Chris Melton's.
And you noticed, can you describe the juror's reaction, defense, and prosecutor closing? Salty ma'am, I'm going to do a general statement of reaction. General statement. They reacted about the same on both sides. They reacted about the same on both sides. That's what I'm going to say. Now, after the trial, I can give you some details. But as of right now, they reacted the same for both sides. You're not going to get me in trouble, Salty Mom. You are not going to get me in trouble. They acted the same on both sides. It's obvious some of you guys did not get the memo of me getting reprimanded. Not me, but media people getting reprimanded not to give the specifics of the jurors. And you guys constantly come in here trying to get me to get in trouble. I'm not going to get in trouble for you guys. No. Not going to get it. Not going to get in trouble. The trial is not over yet. It's not over until a verdict comes. That's when the trial is over. Can you play where he talked about when Chris said what I caused and then changed it? It's at the end. He said it at the end. Hold on, let me play it for you.
Miss Ashley P.V. Hall told us something inconsistent with what Chris Melton said. She had to admit when we were asked if we needed to, we were prepared to. But Mr. Faust didn't have to present that. They were required to, and they did. Dinner with your family, and you receive a knock on the door. You go to the door, you open it, and her entire case, for everything in this case that I've seen, she's seen. Instead of saying, hey, you know what? Let me follow the evidence. Miss Hinkle's word for it. It's not possible. Every person that has to be charged with the crime is presumed innocent. We ask that you find Mr. Faust not guilty.
Hi.
Murder. Count 3. And we discussed what proof beyond a reasonable doubt means. Count 3. We ask that you find Mr. Faust not guilty.
I'm trying to find the spot.
I may think of something later that I forgot to say, but Mr. Faust trusts you. He trusts you with his life. We trust you. I want to thank you for your time and your devotion to this community, the United States of America, as well as the state of Georgia. In regards to malice murder, which is count 1.
I'm trying to find the transcript. I don't see a transcript.
We ask you to vote not guilty.
I don't see a
In
transcript.
regards to felony murder, count 2, we ask that you vote not guilty. In regards to felony murder, count 3, we ask that you vote not guilty. In regards to felony murder, count 5, we ask that you vote not guilty. In regards to burglary, count 6, we ask that you vote not guilty. In regards to aggravated sodomy, count 7, we ask that you vote not guilty. In regards to rape, count 8, we ask that you vote not guilty. In regards to aggravated assault, count 9, we ask that you vote not guilty. In regards to aggravated sodomy, count 10, we ask that you vote not guilty. In regards to arson in the first degree, count 11, we ask that you all vote not guilty. In regards to possession of a knife during the commission of a felony, we ask that you vote not guilty. Court's indulgence.
I'm trying to find that spot. There it is. I think this is it.
And forgive me, I skipped count 4. Count 4, felony murder, it's the exact same thing. We're asking that you all vote not guilty. There was something that I didn't mention. I was trying to be considerate of you all's time and kind of get through the argument. But there was something said by Agent Bigham.
There it is.
I'll end on this note. She stated that Chris Melton's DNA was supposed to be there. There was her statement to you all when we asked about the DNA. Something that isn't appropriate in this case is to assume that because someone is a boyfriend and the timeline doesn't fit, that they are entitled to someone's body.
And that's
Ms. Baker could tell Mr. Melton no. His DNA being there doesn't automatically mean he has access to it. And I would tell you all to reject that statement from Ms. Bigham, but also use that to judge her credibility. She would rather tell you that Mr. Melton's DNA is supposed to be there, despite it being in a place he said that it shouldn't be, right? They're saying, hey, this guy may not have committed this crime. She chose Mr. Faust's DNA as the DNA that shouldn't be there versus the guy that told her, yeah, my DNA shouldn't be there. That isn't anything that she did. But I submit this case to you all. I want to thank you all for your time, your attention, and your patience with me throughout this trial. On an ending note, if I have done anything to offend you,
okay. Listen, this is what I wanted to say to you guys. He kind of put the pieces together of the things that they did not do with Melton, and he mentioned how when why they did not go after a person who basically had so much circumstantial evidence, I mean, some more of concrete evidence against him, and then went after someone that, without saying, someone that really has no reason to be so brutal. You know what I mean? The type of crime, the type of unaliving that happened to her was someone that had to been close to her, because it was more personal than anything. He talked about how that person took the laptop because it had personal things in it. Okay, how they took the time to clean and wipe, and how they were able to come into the house without having to figure out the keys, because the person knew exactly what key to use in the household, because they were in a relationship type of thing. So he kind of put those pieces together to help you understand that why would a stranger have a reason to burn up the place, to hide evidence, to scrub the place down, and to beat her as bad as that person did? It was personal. It was rarely personal, because if somebody's somebody who's a stranger, they're not gonna go through the length of trying to cover up their tracks. They're not. They're just gonna do it and keep going. You get what I'm saying? They're not gonna sit around and clean the place up. And they knew exactly how long the roommate was gonna be gone. You know what I mean? It was somebody that knew everything about her. Had spent some time, know her ins and outs. It's not going to be somebody just met her just like that. Because remember, when they were looking, they saw no connections to Faust and Tara. They had no connection whatsoever. And the only thing they put it together then was saying that he lived around the corner from her. He didn't know her. You could live around the corner from somebody and not know them. You understand what I mean? So the person that actually did had to be somebody who was close enough to. And then, remember what he said that he's claimed the argument they had was because of a porn video tape, right? And that is something that she did not do, right? That type of sex type of action she did not do. And how did that person unalive her? They did it with that type of thing that she did not like to do. She did not do. They sodomized her. He sodomized her. And you don't know what was on that tape. It was probably something disgusting that she didn't like. So it kind of put the pieces together of his motive, and you don't know what upset him. It could have been because she didn't want to be with him anymore. And if I can't be with you, nobody can. That type of attitude. And he might have found out that she was seeing that other guy that worked with her. You never know what was the reason, what was happening. So we can continue this conversation tomorrow. Now I'm going to go ahead on and get off this live. Give me some sort of medicine, because I feel myself catching a cold from that courtroom. So I will see you guys later, and we can get into this in a little bit in depth. what I would like to do, I was trying to do one of those meet thing, you know, like Google Meet, and I give you guys some details on the Google Meet, some details, stuff that's not in the public, like the details. You get what I'm saying by details? Hint, hint, details. So tomorrow we can have a principals meeting for the details of the things we will share. I'll share with you guys the details. Okay? The details of, you know, the stuff that I can't tell on my channel. Okay? All right. See y'all later. Good night, everybody. Peace out.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me, we laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment chat, keeping the vibe so right. Together we shine like stars in the night.